People versus Sims. Counsel?
Thank you, Your Honor. My name is Noreen McCarthy, and I represent Mr. Sims in his appeal of his conviction out of St. Lawrence County. May it please the court and opposing counsel. I notified the court this morning that Mr. Sims had been released. I just learned it this morning.
And I was going to ask you, counsel, if that affects what you might, as I understand, let me put it this way. As I understand your appeal, every form of relief we might give you would end up with essentially a vacator of the judgment and a new trial.
Right.
And I'm not certain whether you know or whether Mr. Sims would want any relief at this point.
I think that he would, Your Honor, but I have to be honest, I haven't talked to him today. I have to actually find him. But I can update the court on that after. But he did indicate before that he was interested in that, so.
Okay.
Counsel, you are not asking us then to give you specific performance of the originally agreed upon sentence, because that seems like it would be moot at this point.
Right, that I do believe is moot. I
Well,
would agree
has he
with that.
completed the sentence, or he's out on some conditional release? What, do you know?
He's on parole for another 5 years. His sentence included 5 posts.
Would that be the same if it was the original sentence or the sentence that was imposed? I mean, the original agreed upon sentence, I'm sorry.
It's a good question. I'm not sure. I can check on that, too.
I guess whether it's mandatory under the law, right?
But it might mean, though, that if he ended up getting resentenced or his parole revoked, that he might have a longer sentence. So,
Right.
because he
That's
did
why I was
serve-
asking.
Yeah, he did serve actually exactly 6 years. I checked. He was originally arrested in December of 2017. So in that respect, I guess it's not moot, the Outley issue.
You're saying the outlay issue is not moot?
I think it's not moot if that sentence is still
Because he's
hanging
on
over-
PRS? Is that what you're saying?
Pardon me?
Because he's on PRS?
Yeah, because if it gets violated, then he
Yes,
still
he's-
has that hanging over his head.
Back in.
That's right, and that's actually all he would have hanging over his head at this point, is that 1 year.
Thank you.
Oh, I'm sorry, I thought you were going, up here, sorry. I thought you were saying it was not moot because were he granted a new trial, he could conceivably be acquitted.
No, I had been thinking that what we would have possibly asked for, or if the court had found in our favor, that they might give specific performance, which I think would have been one of the options. And I don't think that that obviously, well, it could work, obviously, because, again, if he gets violated, then he does have that 1 year hanging over his head.
Then do you want the plea vacated?
I think at this point, we would like the plea vacated, yes. But I think that that is up to the court to make that decision on this, what it thinks is appropriate. I think either way, if the court finds that,
And that is it's understood that he could face greater.
only,
If there were a trial instead of the plea, he
Right.
could face more time.
but that would be any time that would happen, whenever you appeal, if you.
Oh, that's
a plea.
understood.
Yeah,
It's
so-
just the fact that he's out right
Right.
now, one would pause.
You're right. He probably doesn't want to go back. I agree.
Like any other human being?
Right. I'm sure he's celebrating. So I considered 2 issues on that point one to be interrelated. One, was there a breach of the agreement? And I think if there's a.
So what exactly was the agreement?
Yeah, so the agreement was for 6 years, and I believe 5 posts. I'm just going to put that
And were
out
there
there.
conditions preceded?
The conditions were, initially, they gave the original Parker warning. But the defendant balked at that, and he balked at it, and you got to picture yourself in negotiation for any kind of contract, and said, wait a minute, I've been getting these threats that if I take this deal, they're going to ticket me. And he explained to the court later, I'm kind of outspoken, and that's why they would do this. And he hesitated, and the court said, well, okay, relax, calm down, and gave him what I call the revised Parker warning. And the revised Parker warning was, just because you get a ticket, that doesn't mean you will lose the benefit of your bargain. He said, I'm going to take a look at it, Attorney Massey's going to have a chance to respond, and then he gave him very specific instances where he'd say, you know, look, you get in a fight, an unprovoked violence or something, then you're going to lose your bargain. And to me, that was, you know, you're negotiating a contract and the.
So is it your argument that the court limited the things that could violate the agreement?
I think, number one, the court specifically said, consistent with Outley, that if you just get a ticket, you're not going to get violated, or you're not going to lose the benefit of your bargain. But I think the court also said, look, if it's some stupid little thing that you get a ticket for, you're not going to lose the benefit of the bargain.
Basically, the court said it depends. I'll look at it.
I'll look at, but it was very specific, and it didn't state anything other than this unprovoked violence. But of course, we can all imagine instances that would warrant.
And that could not be an example of things that could in fact trigger it?
It could be, but the court didn't say that. It said, you know.
It seemed to be, in the record that the court is giving examples of the type of inquiry, right? So I'm not going to just do this, you know, you get the ticket, your lawyer will have a chance to respond. If it's these types of things, this, you know, may be very abbreviated if you punch somebody in the face, you cut in front of the line or whatever the examples
Right.
were. But then after that, as I recollect in the transcript, the court then says, and you can't violate any of the prison rules.
Right, but that's what he was found not guilty of by the prison board. There were 4 charges. The sexual harassment one, they found insufficient or without merit, and they did not find him guilty of failing to follow the jailhouse rules. Those were the two.
No, but didn't what they find him guilty of violate the rules of conduct of the prison?
No, they found him guilty of harassment, and I forgot the other one.
And then
Violating the rules.
I thought, no.
Violating the rules.
I thought the violating the rules, they found him not guilty.
But the harassment, it wasn't a penal law harassment, correct?
Right, and that's the other thing, is that none
So
of these
it
were
had
crimes.
to be prison rule,
Had to be what?
a prison rule that he violated.
Well, yes, you could look at it that way. I can see your point on that one, certainly.
I'm sorry, you're right, it's not the rules, it's disrespecting the officer.
Yes, it was a disrespect, and you could say that those were all rules of the jail, but the specific one about not violating the jailhouse rules, and he says, oh, I have no problem not violating the jailhouse rules, and he never did before and never did after. I think the problem here is, and going straight into Outley and why we have Outley, is this due process issue. And so we can say these specific things about, well, did he commit these 4 offenses or not? Or was the judge referring to those 4 offenses when we're talking about the promise the court had made? But in the end, the court really based its decision to not commit to its agreement on those 2 complaints issued by the correction officers.
They weren't complaints, they were findings, right?
Well, the 2 correction officers filed these complaints,
Right.
and the disciplinary board held a disciplinary hearing where back then the defendant wasn't entitled to have counsel. He was by himself. Those officers did not show up. The complaints weren't signed, they weren't sworn
Were
to.
any of those arguments made to the trial court?
No. No, actually, they weren't. But they might have been made to the disciplinary board had the defendant at that time had the right to an attorney. Today we do, but back then he did not. And so, to me, it seems, in terms of Outley and whether the court complied with that, which I think is very intertwined with whether or not the court broke its promise to not renege just based on the fact that you get a ticket, is that's where you get this balancing. And it's hard to imagine in any court of law in this country that somebody is brought before the court based on a complaint by a police officer that is not signed, not sworn to, for which there's no corroborating evidence, and the
So
police officer...
what should the court have done?
I think the court, at that point, when we know before the disciplinary board that the correction officers didn't show up, I think if you have this balance, that the balance that these were malicious and baseless, which is what Outley talks about, is obviously clear in the record, because he'd been threatened before. If he had raised this afterwards and said, oh, by the way, Judge, I was threatened, but he didn't. He said it beforehand, And then you've got these correction officers who couldn't even sign anything swearing to what they were alleging.
But defense counsel didn't dispute that he said what he was alleged to have said. Did defense counsel? I thought not.
He did not do any investigation, as far as I know. I didn't see any request, any subpoena request for anything. And I think you're right, he tried to argue to the court. He took the position that, look, Judge, even if this was true, you can't, that's not what you had said to begin with. I think the problem for this defendant at that time, and maybe is true of most people going before disciplinary boards in a prison, is the guys don't show up, the correction officers don't show up. There's no evidence because there's no video, there's no witness. How is he to defend
But
against
none
this?
of that was presented to the sentencing court. No, the defense lawyer, the defendant didn't say I wasn't represented, my client wasn't represented, I want these people to come in here and testify as to these incidents. No request was made. In
It-
fact, as Judge Halligan was saying, the conduct was fairly conceded.
Yeah, well, that's an issue going to ineffective assistance of counsel, I think, because had he at least issued a subpoena to the prison to get any, or the jail to get any kind of surveillance or notes or anything else, that might have been helpful. And had he made these kind of arguments, perhaps that would have been helpful. Had he called, I kept thinking about what would have happened if he had called those correction officers to testify. So either they would have to continue, I'm going to assume these are lies because they wouldn't sign it and they wouldn't swear to it, to testify.
Well, but if they were clearly not truthful, why would defense counsel not have contested the truthfulness?
How do they prove that in a situation like this where there's no video and there's no witnesses?
But there's not even, as I read the record, correct me if I'm wrong, there's not even any indication. Defense counsel didn't say, for example, what you're saying now, I believe, right? You're suggesting that perhaps
Right.
those statements were not true. I didn't
Right.
see any indication along those lines.
No, I didn't see anything either in the record. The best that we have is after, when the defendant gets to speak and he has the statutory right to speak at the very end, and the judge has already made up his mind, it's the defendant who tries to tell the judge, hey, look at the coincidence. They do that the very day that I, enter my plea. They had been threatening me with that. I just think there's overwhelming evidence that these were malicious and baseless. And if the court had carefully considered this and really done a more thorough inquiry, as he was obligated to do under Outley, some of that would have been fleshed out here. I think the court, I agree that the defense attorney failed in his obligation here, but I can see that he might have been thinking, what's the point? They're going to get up there and say the same thing. There's no evidence to be found here to help this guy. But the court still had an obligation to look at everything here, to look at the fact that they were not signed, that they didn't show up, that they had threatened, and that it was the very same day. And you have those four things over here. And this is the side that's, is it malicious and baseless? Well, that's pretty heavy. And then you've got only their statements.
But you never argued about the adequacy of the hearing. Again, your
Yeah.
two arguments were it was involuntary because the court gave him an inaccurate sentencing range, and it was insufficient because his statement to the probation department cast doubt on whether he was guilty. I mean, it's very different.
Are you saying did I or did they? I mean, I think I did.
Did they?
Yeah.
Is it preserved, I guess, is what we're getting at.
Oh, I think it was preserved because I think it's simple enough to preserve this where he starts and says, the defense attorney says, well, that's not the warning that you gave, and now you're violating, you're not being consistent with the warning that you gave. And when the defendant gets up and says, wait a minute, Judge, obviously these are bogus because they were done the very same day, and remember, we told you that I had been threatened. And so I think in that respect, to the best that he could, even the defendant tries to preserve it.
And before that, after saying, this is not,
Yeah.
I take your point that counsel gets up and says, that this is not really the bargain, right?
Is that what?
This is not really the bargain, right? That's some version of what your arguing defense is saying before the defendant gets up when counsel is in this colloquy with the court. Doesn't counsel also remind the court that the counsel had put before the judge at the time of the plea that defendant was concerned about getting the ticket In
Right.
addition, he'd not done anything before this, not done anything after this incident, so it
That's
is a
right.
reminder of the prior.
He does remind him, which is the only way that we know it, because on the June 21st status hearing.
Well, can you
that-
infer from that counsel is also saying to the court, you really have to look behind these complaints? It seems more than coincidence.
Right. I agree with you 100%. And in terms of the preservation, I think my time has expired.
Go
but
ahead and continue.
I was just going to say that Parker says you don't have to preserve this. And so I'm not sure that preservation is really the issue here. I think it was factually preserved, but Parker and the other cases say it wasn't because it renders his plea involuntary, and you don't have to preserve that one. And then we have the waiver that clearly would not have covered this. If the court did unlawfully or improvidently breach its commitment and impose a sentence, that would have been an unlawful sentence to impose. And so the waiver doesn't cover that. And then again, we get back to whether it was a voluntary or involuntary plea. So we would ask at this point to have the plea vacated.
Thank you. You know, I interrupted you, counsel, at the beginning, and I forgot to ask if you wanted rebuttal time, so I'll give you 2 minutes.
Thank you very much.
Good afternoon, Your Honors. May it please the Court, James Gibbons for the people. I'll start on the mootness point just for a moment. We fully agree this case is not moot. I'll commend to this Court's attention a SCOTUS case that is, I believe, on point. It's Pennsylvania v. Mims. The site is 434 U.S. 106. It's 1977. And SCOTUS said, I believe it's footnote 3, said that even if the sentence is completely served, which is not our case here, he is still on PRS, even if the sentence is completely served, direct appeal is not mooted because there are continuing collateral legal consequences. And SCOTUS said, in that case, well, what if Mims reoffends? That would be a predicate felony, and so this is not moot. All of that said, let's turn to the Outley issue. Now, this claim is unpreserved, and I believe my esteemed opponent actually just conceded it's unpreserved. Your Honor asked, were any of these arguments made below? And the candid answer is no, none of these arguments were presented below. But even despite that, appellant actually got everything Outley promises. That's because Outley promises 2 things. First, if you deny the alleged misconduct, you'll have the opportunity to show that the allegation lacks foundation. And that's what happened here. The court read into the record the allegations that were contained in the PSR, and then turned to counsel and said, would you like to address whether or not I'm bound by my commitment made at the plea proceeding? And counsel then presented a number of
So
arguments.
if he wanted to call witnesses at that point?
He could ask to do that, certainly, Your Honor. But there's nothing he certainly didn't ask to do that, and there's nothing in the record to indicate that that was something that either counsel or even appellant, until he then got the sentence,
But
wanted
is
to
it
do.
your argument that he was put on notice that that he had an opportunity to give the court something to consider with respect to the allegation?
100%, Your Honor, that's exactly correct. The court opened the floor, he made the arguments he wanted to make, they didn't carry the day, so now he's got a whole new passel of new arguments for this court to consider.
And what about the argument that between the statements of counsel and something that was said off the record, which we have some inkling of what might have been said off the record, that was enough to alert the court that it needed to look more deeply into the nature of these charges and the way that they were adjudicated?
Your Honor is entirely right that we're not totally sure exactly what happened, but
you get the impression it's something along the lines that he said, I knew that if I went to the facility, I was going to get ticketed.
Yes. And the answer to that is that turns to then the second point of what Outley promises. Outley promises that if you do dispute any aspect of the allegations against you, the court has to have a legitimate basis to believe the misconduct occurred, and that we have that here. Yes, appellant made some argument that somehow it was essentially a selective prosecution argument. He says, well, he didn't dispute that these words came out of his mouth, but he said, well, I'm a boisterous and opinionated person, and they don't like that. So this had never been a sexual conversation with the female officer before. I had made similar comments to the female officer before, but I hadn't gotten written up for it now, and I was only written up because of the plea. And the court was then required to at least listen to that argument, right? That's what Banks says. That's what Fiamegta says.
Is there an obligation beyond just listening? Would that trigger more on the part of the court?
Well, the court has to have a legitimate basis. So let's look at what's on the other side of the ledger, right? We've got the PSR itself, which has got detailed statements from 2 mutually corroborating witnesses. We've got the jail disciplinary hearing.
Yeah, well, what weight should we give that, if any, to that hearing?
Well, that is a hearing at which appellant had the opportunity to be heard there as well. Appellant was entitled under, I don't know how much of this is actually in the record about exactly the procedural safeguards there, because again, this is an underdeveloped record, because there was never a challenge to the jail disciplinary hearing procedures. But appellant was entitled to seek to present witnesses or seek to present.
The correctional officers didn't testify, is that right? Is there any question
They
about
didn't
that?
testify in court here, and to the best of my knowledge, they didn't
Right.
testify at the jail disciplinary
I
hearing,
meant
which
at
is
the
different
disciplinary
from
hearing.
whether appellant could have demanded that they testify. He never asked for
But
that.
they never signed the ticket or documentation charging him.
The PSR is a fax, and I don't know whether the original documents that the officers completed were ever signed. I know that we don't have a signature. But I don't know that we can necessarily infer from that no signature ever touched the page. And then, in addition to all that, we've got appellant admitting, and this is pages 76 and 77 of the appendix. We've got appellant himself, out of his own mouth, effectively conceding that these words had come out of his mouth and were directed to the female officer. And I know that appellant now is saying, well, that was a denial or an adamant denial. Again, he was found to have violated 2 provisions of jail rules. Sexual harassment.
I'm sorry, can you quote for me what you say is his concession that he said the words that
Well, this is, I'm
they
sorry. Your Honor.
alleged he had said to the female officer?
He does not explicitly say, I uttered those words. You're right, Your Honor. But what he does say is that I don't consider that harassing because me and the female officers had had multiple prior conversations and it had never been a sexual conversation prior to that. But here's a key point. That might potentially go to whether the allegations contained in the PSR rise to the level of harassment in appellant's particular evaluation of that term. He doesn't dispute the disrespect charge. Again, the PSR details how the female officer repeatedly told him to desist from this conduct. The male officer came over and said 2 or 3 times, you must stop speaking to the female officer, you must go back to work. Appellant's response was to turn to the male officer and say, you mind your own business.
But even if you were to read it as you're proposing, I'm not sure how it would disprove what I think someone suggested was a selective prosecution type response.
It doesn't disprove that, Your Honor, but in light of...
And that was something he alluded to on the front end, right? He essentially said, they're going to write me up.
That is what counsel later said that appellant said. We don't actually have that conversation on the record, but we're not disputing that something to that effect occurred. That appellant's statement at sentencing doesn't disprove the selective prosecution argument, but again, the Parker warnings were not comply with the jail rules unless you get selectively written up for it, in which case it doesn't count, right? All of appellant's arguments below were the conduct alleged in the PSR shouldn't count for the purpose of rescinding the sentencing promise. And the court had a legitimate basis that no matter what we might think of the officer's decision to write him up on this particular occasion or whatever pattern of conduct he had before then, the words contained in the PSR, appellant's statements as quoted, which he does not dispute the accuracy of, are scandalous.
Do you think that the revised Parker warnings, if we want to call them that, restricted the court's ability, the universe of things the court might have been able to consider a violation at all, or it's just unenforceable?
Neither of those two things, Your Honor. It didn't restrict it. And if I could just go to the exact text of that warning, because I think the words matter.
Okay, let me see if I understand. So your position, I think, is that the revised Parker warnings are no different than the original Parker warnings.
Not in substance, Your Honor.
Okay.
At the plea, the court starts off with saying, you must comply with the jail rules. Those are the court's words. And then gives 4 examples and then a catch-all. It says, you cannot break the jail rules. You cannot, and all of these are direct quotes, you cannot break the jail rules. You cannot get involved in a fight. You cannot promote some contraband. You cannot disrespect the corrections officers. And then this catch-all, whatever it may be, right? Don't treat these examples as the universe of potential violations. Jail rules are jail rules. You have to comply with all of them, even if I haven't listed them all. Appellant says, can I comment on that, sir? The court says, no, you can't comment on it right now. You talk to your lawyer, and then you can approach. They approach after consulting. They go, and after an off-the-record conversation, the court says, well, let me explain it to you this way. What's happened in the past is defendants would think that because they got promised a sentence, they can do whatever they want without consequence and thereby disrupt the security of the correctional facility. And then the court gives an explanation of the potential procedure and is clearly giving an explanation of what an outlet inquiry looks like. Right? If you come in here and there's an allegation of misconduct, Mr. Massey, defense counsel, will get an opportunity to address it. I will take a look at it. But if it turns out that you did X.
So to that point, and picking up on the Chief's question, when the judge says, so the mere fact that you might get a ticket doesn't automatically mean that you are going to lose your commitment, your position is that that doesn't restrict what he promises he'll do or qualify the initial Parker warning at all?
The only potential qualification, yes, Your Honor, is the answer to that. The only potential qualification is that the court did ensure that if there was a dispute about what appellant did, there would be an outlet inquiry. But there was no dispute here about what appellant did.
Isn't that always the
you read the
rule?
fact that you might get a ticket doesn't automatically mean you'll lose your commitment as simply promising that you'll get an outlet hearing?
That is, well, an outlet inquiry, Your Honor. That is my
Pardon me,
read
yeah.
of this. And indeed, that's
Not
exactly.
that he's indicating that a de minimis violation is something that he might let pass.
No, Your Honor. I don't read that as suggesting that a de minimis violation would be allowed to pass, but it really don't have to reach that question because I don't think there's any plausible argument that the conduct here is de minimis, right? It violates the you shall not disrespect corrections officers. And again, the conduct here, it is egregious, and it is indicative that he's more than just a boisterous and opinionated person.
Is this just a difference of opinion between the opposing sides? The argument made at the eventual outlet inquiry was that when you talked with him about the Parker instruction, you gave him examples of, I'm paraphrasing what defense counsel said, but you gave him examples of serious violations and not serious violations, and this is more like a not serious violation, so therefore you should not give him any sort of enhanced sentence.
That was one of the arguments that counsel made, yes.
And I hear you saying now that that was actually never part of the instruction that was given by the court. And I'm looking at the language, and honestly, I don't know what it means. I'm gonna read just a little further down from where you were. The court says, but if it turns out, based on what is presented, that you got in a fight with another inmate and you punched some kid out because he cut in front of you in a line for the phone or for a computer, that you just hauled off and hit him, well then, I'm going to look at that and say, you lost your right to the commitment. But, and here's the phrase that I have a problem with, if it is something close, I'm going to take a look at it. I have a problem with it because I don't know what it means.
I think it's clarified by, if you continue reading down the very same page, Your Honor, the court reiterates, but you still have to comply with the jail rules. I don't read that as necessarily ruling out the possibility that a truly technical de minimis violation, maybe the court would have chosen in its discretion not to rescind the sentencing promise. And of course, the court has the discretion to overlook a violation of the plea agreement and to still hand down the same sentence. That's why an outlet violation can't actually occur until the sentence is handed down. Of course, if the court said,
did the-
how dare you say this?
And counsel, did the court here give consideration to actually what he was alleged to have done?
Absolutely, Your Honor. The court made very clear on the record that it was disturbed by the specific allegations here, not merely the fact that there was an alleged violation of jail rules, but the specific conduct here. And that was eminently reasonable on these
Did that
facts.
include the ones that he was not found guilty for?
The only thing there was a dismissal of the failing to abide by administrative directives. And then there was a finding that there was no evidence to support an infraction of solicitation or of compulsion to engage in sexual acts. And again,
I'm sorry, counsel, those two that they didn't find evidence to support, were they based, those charges based on the same conduct?
Yes. They were based on the same conduct, but that was clearly the right call, and it doesn't involve a determination that the officers were incredible. Because if you go through, there's nothing in there that actually constituted solicitation. It is, if anything, the opposite. It is offensive and disgusting, but it is not a solicitation to engage in a sexual act. Your Honors, I'm more than happy to address any of the other issues in the briefs, but I do want to just point out on the preservation point very quickly, is that so much of this record is underdeveloped. Again, what counsel should have been able to present at an evidentiary hearing, we don't know because there's never been an effort to develop the record. But if appellant wants to do a 440 motion, that record can get developed and then a court of law can pass on it. But until that happens, there's nothing to review. Thank you, Your Honors.
Thank you.
Sorry, pages got messed up here a bit. 4 times the court told the defendant, if you get a ticket, just because you get a ticket, you're not going to lose the benefit of your bargain.
Isn't that right, though?
Yes.
I mean, isn't that always right?
Absolutely,
And
absolutely.
I mean, I'm trying to understand what's misleading or different about a standard warning here, because just because you get a ticket, if you said and do it, of course you're going to get an inquiry. I think
Right.
everyone would agree, if you just got a ticket and you lose the benefit of your bargain, that's probably not going to hold up.
I think that's absolutely right. And the case that we cite out of the third department says exactly that as well. And that goes back to the arrest, and even
But
Parker says it.
the argument here is you didn't just do this based on the fact that the defendant got a ticket. You looked at it, you looked at the underlying conduct, you gave the lawyer a chance to make a presentation. I think if the judge had just come in and said, you got a ticket, I'm giving you 7 years, then you have a violation.
But the court did do that. In fact, on June 21st, 2018, what was supposed to be the sentencing date,
They gave them 3 months to prepare for the later
I
proceeding.
didn't catch that part of it. Honestly, later he says, when he walks in later, or they start the sentencing later, the judge says, I told you I was no longer bound by my commitment. I told you that on June 21st during that status hearing. And in addition, he did base it simply on the fact that the tickets were issued. And that's where I respectfully disagree with my counsel here when he keeps saying, he did these things.
Well, if that's true, why go through what appears to be the underlying conduct? If it's just the mere fact that tickets were issued, what does it matter the substance of the ticket?
It doesn't matter.
Okay, but all I'm saying is, isn't there in the record that the judge did discuss some of the substance of the tickets?
The judge read from the tickets. That isn't really an inquiry, and the judge had an obligation to make sure that those allegations were based on reliable evidence. And it is not reliable evidence to have a document that is not signed and not sworn to where the witnesses don't show up.
But if it comes from a result of a hearing at the correctional facility, isn't a judge allowed to rely on that?
I think then you have to look at the hearing and say, they didn't show up to the hearing and they never signed these documents.
If a judge is comfortable with that,
Does that really satisfy due process? And in any court of law, other than this instance, or a disciplinary hearing at a jail, which is quite frankly probably why we changed the law here in New York, And these guys now are
But
entitled
at
to
the
counsel.
inquiry, did he make those arguments that they weren't signed and they didn't testify?
They didn't make those specific arguments, but they did make other arguments to suggest that what they were arguing was these are not reliable. The defendant argued this is not reliable because they previously had threatened me. They did it the very same day. Why would I do something like that? He was challenging it. He's not a lawyer. He's not a defense attorney. He was doing the best he could when his attorney wasn't actually doing that. I mean, at a minimum, I think the attorney should have at least issued a subpoena to the jail to say, do you have any video on this, you know?
Is there some question as to whether or not these tickets were actually signed?
Not as
Or is
far as
that
I know.
certain?
And there's nothing in the record that they were ever signed, and I think we have to go by the record. So I have no idea, but the probation office gave it to the court unsigned. The court went by unsigned. If the court had some concerns, they should have gotten the signed ones. You know, I think that that's the problem here. Where is...
Isn't it the problem that it wasn't brought to the court's attention, that one was contesting the allegations because they weren't signed? And then the court could possibly be prompted to say, would you like a hearing with respect to same?
Okay, so that's a very good point. The defense attorney does not raise that, doesn't point that out. However, when I read Outley, it says the court must conduct a hearing, and the court must assure itself that the allegations are based on reliable evidence. It does not say the defense attorney has to ask for that hearing or it's waived. I've not found a single case that says that. Maybe they're out there, but I didn't see
That may
it.
be true, but if the court is satisfied, then the court wasn't asking for anything else.
But if that court, is that due process for the court to be satisfied based on that? In any court of law, let's say you have a domestic violence case, right? And the complainant files a petition or a complaint in the criminal court that somebody's harassing her, but she doesn't sign that complaint, it's not sworn to, and she doesn't show up for the hearing. What is the first thing that the court is going to do? They're going to dismiss it outright. And even in New York, I'm just...
Usually that is brought to the attention of the court at the time and a motion is made and the court acts accordingly.
But the court would be obligated to do it on its own. If they get a petition that's not filed, that's not signed, not sworn to, and they don't show up, they would just dismiss it. In fact, in New York, I was thinking about this, in New York, if you get a speeding ticket, you have the right to ask for the deposition, and if you don't get that signed deposition from the patrol officer within 30 days, your case gets dismissed. So I can't think of a single time, except in a situation like this where the defendant has already pled guilty, he's already agreed to his part of the bargain, and then the court says, oh, no, I'm sorry, I've got this thing over here, whether or not your due process rights are taken care of or protected, we don't care. But that's what Outley does. Outley was designed to protect the due process rights after somebody pleads guilty. So I respectfully disagree that we can just read those allegations and say they are true. I think that that's the problem here. We cannot just read those allegations and say, that's true, and so he should have gotten an extra year, because who in this court would want to be convicted based on an unsigned, unsworn document where the person doesn't show up?
Thank you, counsel.
Thank you.